So Virginia, we got some talking to do about marijuana. So guess what's coming to Virginia July 1st of this year? Virginia is legalizing marijuana in certain ways and certain conditions. A couple things that we need to talk about though are while they're legalizing marijuana in some ways, they are not making it legal to sell marijuana yet. So not until January 1st of 2024 are they going to make it legal to have recreational dispensaries for marijuana and sales and distribution and things like that with a license to sell. So you got to keep that in mind so that you're not getting into trouble on that. The other thing is they're not getting rid of medical marijuana. So all these new laws are applying to recreational use of marijuana. They're not going to apply when you need a prescription. You can still get that through your doctor and can still be treated for whatever conditions and course of treatment that your doctor sees fit. So just know that those are two really important things I wanted to start out with. Now let's get down to the good stuff here. What exactly is going to happen July 1st? So first things first, they are going to legalize marijuana. It only is going to apply to adults ages 21 years of age or older. So you hear this, if you're under the age of 21, this does not apply to you. Sorry, you're gonna have to wait a little bit. It also only applies to adults 21 years of age or older carrying under an ounce. So if you have anything over an ounce, that's gonna be in a different penalty range. It's only going to be legal for you to possess small amount, which is under an ounce. You can also only possess that in a private setting. So if you're out and about and it's on your person and things like that, you're fine, but you can't use or consume it out in public. So when I say you can't have it out in public, you can have it, but you can't be consuming or using it, because if you do, that, my friends, is going to get you into some trouble. If you violate this and it's over the ounce, then you're looking at a $25 fine. If you have more than a pound of marijuana, you're not just looking at a $25 fine anymore. You're looking at a felony of 1 to 10 years and or a fine of up to $250,000. Okay, so it gets a little bit more steep if you are having way more than what Virginia is currently allowing. They have some other penalties too that you need to be aware of. So anyone under the age of 21 is not legally allowed to possess this anyway, but if you're on school grounds when school is in session and you have marijuana for ages kindergarten up through the 12th grade, you're looking at a class 2 misdemeanor, which means up to 6 months in jail and a fine of up to $1,000. If you give it to a prisoner, either at the jail or detention center, you're looking at a class 1 misdemeanor, which is up to 12 months in jail and a fine of up to $2,500. So that can get you into some trouble as well. You cannot, as we talked about, consume or use this stuff in public. So that means not on your front porch, not in your backyard, not in a car, not at a concert, not at a soccer field, not at any of these things. If you violate this, the first time offense is a $25 fine. The second time it's a $25 fine, and they're going to make you do substance abuse treatment and or education. The third or subsequent time that you do this, you're looking at a class 4 misdemeanor, which is a fine of up to $250. Okay. So you got to be really, really careful. You're escalating these, even though it's a class 3 misdemeanor and it's only a fine, it's still a criminal offense. It's still something that can go on your record and can have an impact for you. Okay. Another big thing that we got to talk about, Virginia, is it is illegal, or it's going to be illegal. It's currently still illegal because you're not allowed to do it, but starting July 1st, it's illegal to consume or use marijuana while you're driving a motor vehicle on a public highway. That goes for the person driving, that goes for any passengers. So if that car is driving on a public highway and you're consuming or using marijuana, then you are going to get in trouble. Okay. We also need to talk about another issue that we got going on, which is that there is a presumption that they're making that you have consumed or used marijuana if you meet one of these 3 things. And I apologize, I'm going with my cheat sheets here because we have a lot of things to talk about here with this marijuana law, and I've gone through it several different times, and I want to make sure that I'm not missing out on any information that all of you need to know about. And so I have some cheat sheets just to make sure I'm hitting all the points that I need to make, because it's a lot of information and it's all brand new. So there is a presumption of marijuana that you have used it, or I'm sorry, there's a presumption that you have used it or consumed it if it's in an open container vehicle that's found in the passenger area of your car. So think front seat, back seat, any of those areas are considered the passenger area of a vehicle. And so if it's found in that area and it's open, it's not a sealed medical container or sealed marijuana container where it's labeled from where you purchased it or whatever, then you're going to be deemed to have consumed or used that marijuana, even if you haven't. So the best place to have this stuff, if you're driving around once July 1st hits, is to keep it in your trunk, so you don't have to worry about that. They're defining under our statute, an open container is any vessel containing marijuana, except if it's in the originally sealed manufacturer container. So that means if it's not in that, or you have it open, you're going to get into some trouble with that, and they can suspect you of DUI and things of that nature. So just keep it in the trunk. You don't have to worry about that, and don't use it or consume it while you're driving. Keep the police off your back. Don't bring attention to yourself with that. Okay. The other way that you can be presumed to have used or consumed it is if you've partially removed it. So let's say you have half of it out, or it's been the container's been tampered with or something, you got some on the seat, whatever's going on, that's going to be a way that they deem that you've consumed or used it. And then the final way they're going to do that is if you're exhibiting the appearance, conduct, speech, or other physical characteristics, except for odor, that are consistent with you having used or consumed it. So if they're seeing that you're just kind of out of it, not answering questions, aren't being serious in terms of listening to what the officer has going on, things like that, they may suspect you of having used it and been driving or be under the influence. So that can get you into some trouble. Some big things that Virginia did, they did this starting March 1st, but they've kept it in this new law that's going into effect July 1st, is that no police officer may lawfully stop you, search you, or seize you or any person, any place, or anything solely on the basis of the odor of marijuana. This is key. For years, we've had officers saying, hey, I smell marijuana. Now I'm going to search that car. I'm going to search that backpack. I need to search your pockets or whatever. They can't do it just based on the odor of marijuana. Now, if they have other evidence, they'll be able to do it, but they can't do it just based on the odor of marijuana. Also, no evidence discovered or obtained, including any evidence that you gave consent for them to search or take, is admissible at any trial, hearing, or any kind of proceeding that's going to court. So even if they somehow convince you to agree, or you give them permission not realizing you didn't have to, they can't use those things in a prosecution against you, which is awesome. There's two exceptions to what I just told you. So the odor of marijuana and not being able to use that evidence against you does not apply if you're a commercial vehicle driver. You guys can't have that and stuff in your car at all. So I don't care that you want to use it when you get off of work. I don't care if you need to purchase it on your way home before you trade in your work vehicle for the night. Whatever's going on there, if it's in that car, like, these things don't apply to you. The other place this does not apply is at an airport. So you can't be traveling with it. You can't have it on there, and you're not going to have the same procedural requirements that help you out in those type of situations, because they're not allowing that. Also, you got to remember, even though Virginia is making all these changes July 1st, federally, this law has not changed. So marijuana is still not deemed to be legal under the federal law. So you still have to be careful in other states and on federal properties and things like that. So that's something else that you got to keep in mind, no matter what Virginia is deciding to do here. Okay. All right. So we talked about the adult stuff. Let's talk about if you are 18 years of age or older, and you are caught with this, you're facing a $25 fine and mandatory substance abuse treatment or education or whatever it is that they're going to require. If you are under the age of 18, you're going to be treated as a juvenile delinquent, and you're facing the same fine and the same treatment and education and things like that. Little bit differences is that once you get in the juvenile system, they can start having you do other penalties and violating and things like that. You're going to be treated as a delinquent, as adjudication of delinquency, versus an adult who's being convicted on things. So you're going to be monitored under a different process. The bottom line here is, until you're the age 21, this isn't going to be legal for you. No matter how old you are, any person can have a deferred finding on something like this. If you end up being brought to court for a charge like this, and you have never had a drug offense before, then the court can entertain giving you a deferred finding. And the things that that's going to include are probation, substance abuse treatment and or counseling, whatever it is they're deciding that you need. If probation can let you do these things, or another agency, if they approve it, they're going to do substance abuse screening on you to make sure you're not testing positive. You got to do 24 hours of community service, and you have to try to maintain or seek employment. Those are all the things that they're going to require as a condition of this deferred finding. If you do everything right, then that could ultimately be dismissed against you. If you mess up and you don't do those things, then you ultimately could end up with a conviction on your record for this versus having the dismissal. So it's just still something there. We've always had that over the years for possession of marijuana, and that's still present in the system, even though they've made these penalties a little bit less. Okay, now let's talk about selling. You can't purchase marijuana right now in this state unless you have a medical marijuana card and you can go to a medical dispensary and be able to get your prescription or whatever. That way, that technically would be purchasing it. Other than that, until 2024, when people have applied for licenses and they start making recreational use to the point where you can sell it if you're meeting all the criteria that they want you to meet, you can't sell it. And so if you sell it and it's a first-time offense and you're caught, you're getting a class 2 misdemeanor, which means you're facing up to 6 months in jail and a fine of up to $1,000. If you have a second or a subsequent distribution like this with marijuana, then you're looking at a class 1 misdemeanor, which is up to 12 months in jail and a fine of up to $2,500. So you can get my gist here. The more you do this, the more you're going to keep getting into trouble, and then more you can face jail and fines and all those things. So something we got to talk about is one thing they're making. It's called adult sharing, and they're going to allow you, if I'm in possession of an ounce of marijuana and I want to gift it to you, as long as I'm not selling it or taking any kind of monetary value or trading value for it and things like that, I'm allowed to gift you up to that ounce of marijuana. A few things apply there though. I can only gift it to somebody that's 21 years of age or older. I can only gift it to somebody that's not intoxicated. I can only gift it to somebody in a private setting. I can't do it in a public area. So if it's done publicly, if you give it to someone under the age of 21, or if you give it to somebody that's intoxicated, then you're going to get yourself into trouble, and it's a class 1 misdemeanor. So again, you're looking at up to 12 months in jail and a fine of up to $2,500. So it's very, the penalties have gone down a little bit, but they're still there, and the threat of a criminal conviction and of jail time and things like that are still very much real in Virginia. So let's talk about the next part of this new statute, which is going to be cultivation or growing the plants, because guess what? They're not requiring a license for people if you are going to grow marijuana personally for yourself. And so there's some things that are come into play here. Number one, you can only do this at a place where you primarily reside. So you can't do this at multiple households. So wherever you primarily are living, that's where you're going to be allowed to grow or cultivate these plants. The other thing is you can only have up to 4 plants per household. So what does that mean? You got 3 families living in a home where you got one brother and a sister and a mom, everybody wants to grow plants. You each can't have up to 4. They define household as individuals in the home, whether you're related or not, that are living in the same place. So even if people are related, even if you're not related, if everybody wants to grow it, you can't do that in the same household. You can only have up to 4 plants per household. So you guys got to sort that out, or else you're going to be getting into some trouble. They put some rules in place for these plants that you're growing at your home too. They can't be visible from the street. And they define that as unless somebody, if someone has to use binoculars or something like that to look into your property or see something, that doesn't count, but it can't be visible from somebody just passing by and those type things. The other thing is they're requiring that you take precautions to prevent unauthorized access by minors to your plants. Now, what that means, I don't know. They didn't define like what taking precautions means. They just said you must take precautions to keep unauthorized minors away from your plants. So I would take as much care as you can to make those plants safe so that nobody has access to them. Each of the plants that you have, whether it's 2 or the 4 that you have per your household, they have to be tagged, and it has to have the grower's name on there. It has to have your driver's license number or your state ID if you don't have a driver's license number, and it has to have a note on there that says you're growing it for personal use. Those things must be on each of the plants that you have in the home. So if it's 4 plants you have, it's got to be tagged on each one of those things. Now, something you may be thinking about is, 4 plants is more than the ounce that they're saying I can have. What they mean by the ounce is if you're out and about, whether it be driving or walking, or they encounter you out somewhere, you can only be carrying an ounce. You're not going to be carrying these plants around, on you. And so the plants are allowed to be cultivated and grown at your home for your personal use. You just can only have an ounce when you're out and about. So that's how they're kind of, I think they've kind of made an exception for that just in the way they've written the law. Now let's talk about the penalties for this. If you decide, you know what, I don't want just 4 plants. There's 3 of us here. We each want 4 plants, and you're going to grow 5 to 10 plants. Then on a first offense, when they catch you, it's going to be a class 3 misdemeanor, which means you're looking at a fine of $500. Or up to $500. If it's a second offense, then you're looking at a class 2 misdemeanor, which means it's a fine of up to $1,000 and jail time of up to 6 months. And if it's your third or subsequent offense, having 5 to 10 plants, then you're looking at a class 1 misdemeanor. I apologize. Let me go back here. So let me start over again with this. So if it's 5 to 10 plants, you're looking at a $250 fine for a first offense. If it's the second offense, you're looking at a class 3 fine, which is up to $500. And if it's the third or subsequent offense, you're looking at a class 2 misdemeanor, which is up to $1,000 fine and up to 6 months in jail. So again, $250 fine if you have 5 to 10 plants and it's the first time you violated it. It's the second time, you're looking at up to $500 fine. And if it's the third or subsequent time that you've done it, you're looking at up to $1,000 fine and up to 6 months in jail. I repeated that twice because I messed it up the first time, and I want to make sure I get all the right information out to you. If you have 11 to 50 plants, it's a class 1 misdemeanor, which is up to 12 months in jail and a fine of up to $2,500. If you have between 50 to 100 plants, this is where we're getting into felony range. You're looking at a class 6 felony and you're facing 1 to 5 years or up to 12 months in jail and a fine of up to $2,500. A judge or a jury has the option to sentence you when you get that type of offense. If we're talking over 100 plants, we're getting into more serious felony time, and there you're looking at 1 to 10 years. So as you can see, just as everything in life and as most laws are, the more that you do, the more that you violate it, the worse your penalties are going to get. Something else that we really got to talk about is, I know people always want that stronger high, or you want to be more intoxicated with it, or want more pain relief, or whatever it is you're looking for, but you cannot manufacture the concentrate from the homegrown marijuana that you're doing at your home. And if you do that, that's going to be a penalty as well, and you're going to be facing criminal charges. So you cannot do that. Make sure you don't want to be facing criminal charges for something like that. Something that I found really interesting in this law is that even though they're doing a lot of these fines and just probation and treatment and things like that, they did give the judges a way to sort of monitor you to make sure that you're doing what the judges want you to do, which is to stay out of trouble and maybe do the counseling or treatment or whatever it is they're asking you to do. And so in addition to any of the other penalties, in addition to any of the other jail time, in addition to any of the other fines and treatment and things that the judges can do for you, a court, if you're found guilty of any of these violations, can also require that you execute a bond penalty of no more than $1,000 with the condition that you not violate any of these new laws for the next year. If the bond's required and you don't give the bond, then the judge can put you in jail for up to 6 months. So these are going to be things that judges are looking to do to make sure that you're doing what you're supposed to do. And if you don't post the bond or you're violating these things, then you're going to lose that bond and you can face the jail time for up to 6 months. So just know that that's a control avenue that the judges are going to have to make sure that people are obeying the law and doing what they're supposed to be doing. So this may not apply to everybody, but if you're getting into court and you're trying these cases, there are some procedural things that your attorney is going to have to utilize when they're in court. And, one of those things is that they've put into the statute that no person shall be excused from testifying to any of these offenses by reason of his testimony tending to incriminate him, meaning just because you feel like it's going to incriminate yourself, you can't plead the fifth in something involving one of these offenses. And if a prosecutor requires you to give testimony in one of their cases, then they can't prosecute you for whatever crime it is that you've testified to. So they've put this in here, I think, to try to help the prosecutors out a little bit, improving cases, but also to make sure you're not getting penalized if they're going to use somebody in a situation like this to testify in another case. If you've had previous convictions or other evidence of prior offenses, those things can be used against you in a trial to show that you've had prior violations and issues, meaning you don't know, you're saying you don't know what marijuana looks like. They might try to use something like that to say, you know what, you've been convicted before, you have possession of it before, those type things. So just know that that's out there. The other thing that they're doing is requiring that the certificate of analysis can be introduced by the person down at the lab that analyzes the marijuana. They need that to prove what the substance actually is. That certificate has to be filed. Your attorney can note an objection to that coming in without having the person there. And if you make a request for that person to be present, it's going to be up to the judge whether to require that person. I think in some cases, judges will just require that person to be there. In other cases, they might want to know a specific reason why you feel you need to challenge that person other than just requiring them to be there just for the hell of it. So that's going to be interesting to see how the judges decide on that, because it doesn't say the court must require the person, it just says the court may. So that leaving it up in the air. Also, this is similar to alcohol right now. If you have a sealed alcohol bottle and it has the alcohol percentage on it, then that's prima facie, meaning, you know, that can prove that alcohol is what's in there and the content that it states on that bottle is really what it is. They're doing the same thing here for marijuana. So if you have a container of marijuana that's sealed from the manufacturer or wherever you got it, whether it's marijuana or a marijuana product, that's going to be evidence that it is marijuana and that it's the percentage of marijuana or the content of it is whatever's on that label. So they're making that a little bit easier for officers and prosecutors to prove. The other thing is they're not precluding any other evidence that a prosecutor or an officer can put on before the court to show that that substance is marijuana outside of just using a certificate and things like that. So to wrap this up, I just want to make sure that all of you that are under the age of 21 know that none of this applies to you, that you are not legally allowed to possess this. This can still go on your record. This can still put you on probation and have you doing counseling and treatment and things like that. So you got to wait until you're 21 to take advantage of this 1 ounce stuff that Virginia has going on in July. If you are 21 years of age or older, make sure you're obeying the laws on it. Don't carry it around on you if you don't need to. Keep it in your trunk if you're traveling in your car. Protect the plants that you're growing. Make sure they're safe, that people can't have access to them. That'll get you into some trouble. Make sure you're not consuming or using this out in public so you don't have to face those penalties. Do not consume or use it or let passengers in your car consume or use it while you're driving and operating on the highways in Virginia. And really, statute says driving, not operating. So it's while you're driving, you can't be using that. So just know that some good times are coming here to get high here in Virginia, if that's what you want to do. But there's also some penalties if you mess up. So if you're selling it, if you're giving it to minors, if you're giving it to intoxicated people, if you're going to be on school grounds, if you're drinking and driving or using the marijuana and or alcohol and driving, if you're doing any of those things that can get you into trouble, that's not going to be a good situation. I hope this helps you out and helps clear things up for you about what is happening on July 1st and what's coming down the road a little bit on January 1st of 2024, when they start making recreational sales legal and you can have licenses and things like that. Hopefully this clears it up. And if it didn't, you just remember you can always reach out to me and Sarah is always there.